Good morning, Your Excellency.
Morning, Shahla.
Yes, Your Excellency. This case management conference is in the matter of case number CFI 056-2022 before Her Excellency Justice Maha Mheiri. The claimant is represented by Nurhan Abdulatif Zaabi, advocates and legal consultants. Lead counsel is Ms. Maryam Razzaq. The defendant is represented by MB Kemp LLP. Lead counsel is Mr. Salah Matu.
Okay, thank you. You may proceed.
Your Excellency.
Yes, Miss Maryam.
As you're aware, Your Excellency, I act on behalf of Fursa Consulting, and my learned friend, Mr. Salamatu, acts on behalf of Mr. Ajay Sethi. I trust that you've been through the case memoranda and are familiarised with the particulars of the case.
Yes.
Okay, great. Firstly, Your Excellency, I'd like to refer you to the case management information sheet, if I could. Do you have that in front of you?
1 second.
Okay.
Okay.
Okay, firstly, Your Excellency, I've had the opportunity to speak to my learned friend prior to the hearing, and we've managed to iron out some of the issues, but there are some pertinent points that I'd like to direct the court to, just to put on the court record, if I may. Firstly is point 6.
Okay.
So this is referred to as some potentially documents relating to the inclusion of an expert witness in the field of banking. As you're aware, this is a typographical error, Your Excellency. This matter refers to disclosure of documents, and we will be asking for a separate direction in relation to the inclusion of a banking expert. So this is not required.
Okay.
Secondly, can I take you to point number 9?
Mm.
Again, no admissions or additional admissions are required in this regard.
Okay.
Again, point number 10.
Okay.
To date, I've no instructions on this, but I will revert to the court, or my learned friends will revert to the court at a later stage in this regard if it is so required.
Yeah.
Again, point number 11B, Your Excellency.
Yes, please.
There's a typographical error there, Your Excellency. This should in fact read 17th of February 2022.
So it's
23, I
2023.
think.
2023.
23. Apologies, Your Excellency.
Okay.
Point number 12A, Your Excellency.
Mm-hmm.
I think what the claimant is essentially aiming for in this regard is a banking expert not to comment upon whether this constituted a formally binding contract, as a legal expert would only be placed to form such an opinion. A banking expert in this instance is required to comment upon what a bank normally sees a facility offer letter as. What would they mean by an offer letter? And that is what the banking expert is required in regards to, not to comment upon whether this constituted a valid contract.
Okay.
Can I then take Your Excellency to point 12D?
Mm-hmm. Yes.
This should in fact read 24th of March 2023. Again, that's a typographical error.
Okay.
point 12G.
Okay.
This should potentially read no. We don't want to limit the expert to video evidence. It may be the case that the expert may be traveling and may have to give evidence by video link, but it's not necessary.
Mm-hmm.
Point number 16, Your Excellency. In this regard, at this stage, I don't have specific instructions. Not engaged in a conversation with my client in this regard, as I've only received instructions in the last 24 hours. But I can discuss this with them and will revert to the court at a later stage. Both parties are open to attempt ADR solely without any assistance from the court at this stage.
Okay.
Okay. And finally, Your Excellency, if I can refer you to point 18. The claimant will not be making any applications in this case management conference today.
Okay. Thank you.
Thank you. Your Excellency, to assist you with regards to the agreed directions, I don't know whether Your Excellency has the agreed directions in front of her.
Agreed directions?
Yes. Case management order.
Yes, I have it, yeah.
Yes, you do. Thank you, Your Excellency. Essentially, the majority of the points in the case management order are agreed, save for 2 points, which both my learned friend and I have attempted to agree on, but unfortunately haven't been able to do so. Firstly, it's point number 7 in relation to witness statement dates, and point number 10, the appointment of an expert. So would Your Excellency like me to go deal with each point in turn, and then we'll hear from my learned friend in this. Firstly, Your Excellency, in relation to point number 7, with regards to the date of filing of witness evidence, the claimant has put forward a date of 17th of February 2023. This is 4 weeks later than disclosure of documents, which will allow both parties sufficient time to prepare witness evidence, and it is a date that should be adhered to in the claimant's opinion. Furthermore, I have had a draft witness statement. I've had sight of a draft witness statement from the defendant, which is clear, concise, and almost ready to be filed as such, Your Excellency. So I'm not of the opinion that any prejudice will be caused to the defendant if this date of 17th of February 2023 was adhered to.
Okay.
I don't know whether you want to hear from my learned friend on this point, firstly, before we progress to point number 10.
Yes. So, Mr. Salah, please, you present your reply.
Your Excellency, thank you very much. We would like to make brief points on this. If you see from point 5 of the production of documents, it says that a document production order should be made by 20th of January 2023. So that implies the court has to take some time to hand down an order, and it might take some time. And essentially, the issue of what witness statement has been submitted by the defendant is irrelevant, because witness statement that will be submitted under point 7 will be dependent on the disclosure of documents. So essentially, to have additional time for production of for submission of witness statements makes sense. We say that 3rd of March 2023 would be better, because it will give court some time to deal with the production order application, and it will give parties enough time to draft witness statements properly and adequately. And there's no prejudice to the claimant if the parties do so by 3rd of March. So that's all we say on this, and unless Your Excellency has any specific questions, we are here to answer that.
No further questions.
Thank you, Your Excellency. In relation to point 10, if I may refer you to point 10, on the issue of experts' reports, Your Excellency, it is stated in the case management order that the claimant shall file and serve any expert report within 2 weeks of the close of witness evidence, taking us to the 24th of March, essentially. I briefly touched upon this at the beginning of the hearing with regards to the requirements of the claimant in this regard. What is essentially required, Your Excellency, as a banking expert, which is pertinent to the issues that are involved in this matter, an expert, a banking expert that can comment upon banking facilities used in the UAE as to what a bank normally sees a facility offer letter as. So what they would be commenting on is what is meant by an offer letter, the implications of an offer letter, and whether this constitutes a binding contract upon the individual who takes this out and the facility offer letter is taken and received by. So that is essentially what we are looking for, and it is pertinent, as Your Excellency will note, to the issues that are outstanding in this matter are essential to bringing this matter to a sensible conclusion.
Mr. Salah.
Your Excellency, we would like to basically comment on this. The defendant does not agree with the claimant's position that expert reports or expert evidence is required in this matter. This is essentially a interpretation of contract matter, interpretation of the term of contract concerning the binding nature of the offer letter, which is a legal issue, which has to be determined by the court, not by expert evidence. And we say that whether the meaning of an offer letter is irrelevant. What is more relevant is a legal issue, whether there was a binding contract, whether the contract in question is binding, and that's a legal issue, not an expert driven issue, not an issue that will be determined by expert evidence. It will be determined by way of legal submissions and then decided by the court, not on expert evidence, but on legal grounds. So that's what we say on this point. And accordingly, no expert evidence is required, and hence this is not a matter where the court should order expert reports. And frankly, the party should not be expending any resources on issues of expert evidence here, and this is to further the overriding objective as well, so that we can, after witness statements, progress to trial, which is in the best interest of the claimant here as well. That's all we have to say, Your Excellency.
Thank you.
Your Excellency, if I may comment upon my learned friend's submissions.
Yes, please.
Firstly, with regards to the issue of legal experts commenting upon the validity of whether this was a binding contract, the claimant acknowledges this, and I in fact acknowledged this at the outset of the hearing. We have no dispute, and to a certain extent agree with my learned friend that a legal expert could validly comment upon such matters. However, as I clarified, the issue here is a legal expert could not comment upon what a facility letter is, what it constitutes, and what this would mean to the issues in hand in this particular matter. Furthermore, the value of the claim is such, namely 966 dirhams, which would outweigh my learned friend's arguments that further expenditure is not required in such a matter, given that the claimants have not been able to recover this amount from the defendant.
Okay, thank you.
Your Excellency, if I may comment briefly. Essentially, what is meant by an offer letter, it's again an issue of contractual interpretation, which a banking expert cannot tell the court. I mean, it is a generic banking expert can say that offer letter should have certain characteristics. We don't require an expert to say that. All we need is this is a matter which squarely falls on the terms of contract. And terms of contract are essentially dealt with by legal submissions by lawyers, which both sides already have in place, and then determined by the court. No expert evidence or an issue that can be framed in the present context for an expert will help this court to determine this dispute. So essentially, there is no requirement here for an expert, and I humbly and request the court to agree with the defendant and not order a expert evidence, not to allow expert evidence in this present context.
Thank you for your submission. Ms. Mariam?
I think my learned friend might have had an IT issue. I think she's fallen away, I think.
Yes.
Maybe we can give her some time to reconnect. Your Excellency, can I suggest the instructing solicitors to get in touch with counsel, with my learned friend, and see if she needs any assistance to log in again?
I think the registry is working on that.
Thank you. My learned friend has just texted me and said that she can't get back in, and she needs some assistance with that.
Sahla, are you in touch with the claimant's counsel?
Yes, Your Excellency, I'm about to email them the link just in case they
Ah.
can't access this one.
Thank you.
Your Excellency, I just got in touch via phone with the law firm, and Miss Miriam should be joining any minute now.
Apologies, Your Excellency. We had technical issues in the hotel. My apologies.
Your
No,
Excellency, if I may, I just wanted to make one concluding remark also, now that my learned friend is here.
Yes.
As the matter stands on experts, even the issue concerning expert evidence has not been framed either in the case management draft case management order or in the case management sheet. So the defendant does not even have the framework to agree on if let's say, even if it was something to consider for the defendant. As things stand, the way the issue of experts has been framed, we again respectfully request the court to look at it objectively and order that there is no need for any expert evidence, because expert evidence can only be required if it can help determine the court decide on any of the issues. Here, the issues are squarely on the basis of the contractual interpretation, which requires legal submissions by lawyers and determination by the court, without any legal expert evidence, without any expert evidence. Those are all. That's all we have to say at this stage, Your Excellency.
Are you suggesting that they apply for expert evidence at a later stage, or are you objecting to the whole idea?
Your Excellency, we object that that expert evidence is required at all in this case.
Okay.
Your Excellency, if I may comment upon my learned submissions, my learned friends and the defendant have been aware of the claimant's intention to apply for expert evidence for some time now, certainly since the draft case management order has been submitted. There is a need as such for the claimant obtaining the evidence, as it is a pertinent point, as I've previously discussed, not to the determination of the contract. However, it would be key in establishing whether and what the facility offer reflects in matters of such nature.
Okay, thank you. I've heard enough in relation to this point. Do you have any other matters you want to discuss before we conclude the session?
No, that's fine, Your Excellency.
Mr. Salah?
Nothing further from the defendant's side, Your Excellency. All of the points, parties are in agreement.
Okay, thank you both for your submissions. The registry will revert back to you in relation to the case management order. Thank you.
We are very grateful for your assistance today, Your Excellency.
Thank you.
you.
Thank you both for your time.